taking evidence of granting approval to a party to do the same. 27.1. The arbitral tribunal again becomes the repository of the evidence which the court orders under 27.3. The arbitral tribunal is the deciding body with regard to the default or refusal of a person to give evidence despite being served with a court process or being guilty of any contempt or direction given by the arbitral tribunal in the conduct of the arbitral process. 27.5. Finally, the arbitral tribunal carries the disobedience default presentation to the court for see para 16. In the present case, the petitioner has come up in revision from the trial court order closing the petitioner's application for summoning the witnesses. 27.5 contemplates such a complaint action only being initiated by the arbitral tribunal in the form of a representation to the court. Now this, see, if the court had said you go and adduce evidence before the arbitral tribunal, it's one thing. But if you go to page 88, it will become clear that the court summoned the witness to himself. Please see 89. Second para on 89. Accordingly, this court on 22nd June 2024 issued summons to the witnesses to secure their presence before this court so as to record the evidence of the witness. Your Lordships have that second para on page 89.
You are the respondent to the arbitral proceedings?
I am the claimant. So your Lordships have granted till 15th November. Let this, I am not at all, of course the arbitral tribunal must proceed, but it can't be that without these two key witnesses which your Lordships have held, that the whole issue is the settlement and his whole case is that 3 crores were paid to these two witnesses. He conveniently drops these two witnesses at the last moment, leaving it to me now.
Because I have a fundamental...
Just one thing.
May I just see page 89.
375 expressly says that if there is non-compliance, if a witness doesn't appear before the court...
No, not the court, the tribunal.
No, right.
It's only the tribunal.
See, 4 says,
yeah,
the court may, while making an order under subsection 3, issue the same processes to witnesses as it may issue in suits tried before it.
Yes, but see,
Then
3.
The court may, within its competence and accordance to rules on taking evidence, execute the request by ordering that the evidence be provided directly to the arbitral tribunal.
That's right.
Here what happened was, Justice Praveen Kumar had said, let the evidence be recorded by the court itself. I remember that.
No, frankly, I don't think so.
Wasn't that correct?
No, he said, let the court send it to me because time was running out. But the court, for whatever reason, chose, if your Lordship sees page 89,
to summon them before it.
All right. Now, once he sets...
But then, persons failing to attend in accordance with such process,
no doubt,
or making any other default or refusing to give their evidence, or guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceedings, shall be subject to the like disadvantages, penalties, and punishments by order of the court on the representation of the tribunal.
Correct. So that is to be read with 3. When under subsection 3, when it is directly to be provided to the arbitral tribunal, now the court's task is over. The court has issued a summons, please remain present on such and such day before the arbitral tribunal. Now, if the arbitral tribunal then finds that witness has not reported, has not adduced evidence, etc., obviously it has to make a representation to the court again that, look, despite your summons, this doesn't happen, this appears to be contempt, etc. But this whole process was obviated because the court summoned it to itself. Now, when he summoned to itself, just see page 89, just see, this was what I went by way of revision against. Please see page 89,
Annexure
P7.
118.
See the second paragraph. Your Lordships have page 8.
According to this court on 22 June 2024,
Yes.
issued summons to witnesses to secure their presence.
the presence before this court so as to record the evidence of witness. Now go to the last paragraph, last 5 lines. Report is filed by special messenger to that effect. Both witnesses are absent though the matter is passed over till 1630 hours. As the witnesses failed to appear before this court, in spite of serving of summons, this court could not record the evidence. Accordingly, the office is directed to resubmit the record to the Honorable Arbitral Tribunal to proceeding further as per law. Now, the whole system breaks down. Now, you send it back. Then I have to again initiate the process. Now, your Lordships have held 1 year is the period. So it can't be like a shuttlecock going back and forth.
So according to you, the court has to now take action against those witnesses for not
Either
appearing.
you issue a second summons, which is normally what would happen. Either you issue a summons to report now, or otherwise you have to take a coercive step and end it there. Now, so I agree with the High Court.
So according to you, the 27.5 has to be read in the context of 27.3.
3.
And that is when evidence is recorded before the tribunal and that witness doesn't remain present.
Absolutely. That is how it has to be, my lord.
Then the tribunal will make an application to the court that is action.
That's correct. But now,
this was a case where a witness didn't remain present before the court itself. In which case the court has to take action.
The court, that's the simple point, my lord. That's a simple point. That's the only, I can't be going back and forth. And
I tell your Lordships why I have a fundamental problem with this. Please have a look at IA 2092934, which your Lordships have already disposed of.
That was an MA, right?
No, that was about 2 weeks ago.
That was an MA, I think.
That is in the MA. They filed 2 IAs. One was for extension of time, and the other was a specific IA where they said, please permit the recording of this evidence. Well, please look at the assertions which have been raised there. Please look at this IA, is at page 6 of an IA for additional documents which they have filed. Please have a look at paragraph 5 of this IA. They make that specific reference to the respondent closing the evidence without calling these witnesses. At paragraph 5, at page 8. Then, my lords, at paragraph 9, page 9, paragraph 7, they make a specific reference to the order of the Arbitral Tribunal of 7th of April 2024. Then, my lords, on the next page at paragraph 8, they make a specific reference to this order of the civil court which they are dissatisfied with. At paragraph 10, they make a reference to the civil revision order, which, my lords, and it was pointed out to my lords that they have not challenged the civil revision order on the last date of hearing.
But then they challenged the order before
and then please see the prayer. Now, the point is this, Mr. Diwan may be arguing this for the first time, but his client is not. That's the difference. And that's why, my lords, I have a fundamental problem. 2 senior counsel appear, my lords, for his client on the last occasion. This entire matter is argued at length for about 15 or 20 minutes. After that, my lords, your Lordships took the considered view that at the end of the day, adverse inference can be drawn against me because I have dropped my witness. Let the arbitrator deal with the matter. And that is why, my lords, your Lordships passed that order of the 9th of September, my lords, which is at page 155 of the main paper book. My lords, let me just read that order to my lords. It's not as if this issue has not been considered. This is a rehashing of the same issue. At 156. Time for the conclusion of the arbitral proceedings have been extended till 15 September 2024 by an order dated 11th March 2024. Applicant petitioner has moved an application before the Arbitral Tribunal for assistance for taking of evidence in terms of Section 27 of the Arbitration and Conciliation Act. The 2 witnesses who were sought to be summoned are, it is common ground, persons who were cited in the list of witnesses, but who were eventually not examined by the respondent. The trial court issued notice to the 2 witnesses, but eventually when they did not appear, the proceedings was closed. A revision application against the order of the trial court was dismissed on 6th September 2024.
That is the impugned order.
That is correct. In this backdrop, as it appears before this court, time for conclusion of the arbitral proceedings is to end by 15 September 2024. It is common ground that the argument of the respondent, who is the defendant in the arbitral proceedings, were concluded on 6th August and 19th August. The award was reserved on 19th August 2024. Then your lordships recorded my concession.
See, Mr. Diwan, the only trouble is this. This was an MA, which they had filed, right? We said that an MA is not really maintainable. We only extend. This was an MA for extension of time.
There were two separate, in the end, there were two separate IAs. This was a separate IA where the prayer, as I pointed out, Manoj, was for permitting of recording of this evidence. But with respect, you can't get...
But once their revision has been dismissed, they are entitled to independently file an
But the
SLP.
point is this. Either my learned friend then should have said, I'm not pressing the MA. I will... sorry, the IA, either they should have said that. They, my lord, sought to argue that IA. They sought to impress upon my lords why these witnesses were relevant. And, my lords, to a pointed question which your lordships put, saying, are you going to cross-examine them? My lords, they said, yes, we are looking at cross-examining them. Today, you change counsel with respect, and you now take the position, no, I'm not looking at cross-examining them because there are two Privy Council decisions against you. So you say, no, they will now become my witnesses. Lords, this is the whole change. Lords, I'm sorry, but his client has argued this position before my lords in detail. After arguing, and my learned friend correctly points out, the impugned order was in fact filed before my lords. And we made references to the impugned order. Now, my lords, should this be permissible in a 136? When your lordships, my lords, have told the arbitrator, if I had not made that concession, my lords, in fact, I stood up and I said,
the arbitral proceedings would have been over.
They would have been over. Now, the point is, I make a concession saying I don't want an ex parte award. Your lordships has to see, your lordships also saw their conduct before the arbitrator. Even now, they did not bring your lordship's order to the arbitrator's attention. I brought it to your lordships, to the arbitrator's attention. Arbitrator wrote to them saying, you have been given liberty. Please make the application before me. I will determine the application. They said, we're taking legal advice. We're not appearing. Till date, they have not appeared before this arbitrator.
Well, I'm the claimant.
I'm sorry. Look, they are not appearing. They have made allegations of bias of this arbitrator before my lords. Justice Praveen Kumar was appointed by your lordship's order, not by him, not by me. Look, those allegations of bias which were made about 2 or 3 months ago when the first application for extension was made, they said, please remove this arbitrator. Your lordship's fellows did not agree with them and they withdrew that. Their conduct in these proceedings, where they've made allegations against the arbitrator, they've refused to appear before the arbitrator. Arbitrator, here's my matter. I make a concession saying very fairly, I'm coming to this court. But I don't want an ex parte award because then that's susceptible to challenge in a 34. Your lordships accepts that submission. They argue this entire position before my lords on the law in relation to 27.5. And my lords, if the arbitrator says you've dropped a witness and he wants to, if there's something adverse that I've done, very well. Plus, let the arbitrator observe that. Why should your lordships in a 136 fellows interfere with this? Submission at the bar that they want to call them as their witnesses. Its submission has never been made before.
Has to then move the...
It was, please go to arbitrator. It's not up. Paragraph 8 had asked them to file an application. They didn't even file an application.
I learned the division bench of the High Court is right, because if you read 5, subsection 5, it expressly says that you ought to have moved the arbitral tribunal that, well, please move the court, that they are not appearing for giving evidence, and therefore you take action against them.
But how can a system work? Just consider, my lords. There is a whole speaking order. I haven't placed it.
The thing is,
speaking order by the arbitrator.
When your client moved the IA before us in the MA, the order of the division bench of the High Court was already there on the record. Your client...
No, we disclosed that, Manoj, because the order...
The IA was argued before us. We didn't entertain the IA. But assuming that is so, The division bench has still left it open to you that let the arbitral tribunal move the court.
And look, if I've dropped a
No,
witness,
but
then
And ultimately, your client is not even cooperating with the arbitrator.
Sorry?
Your client is not even cooperating with the arbitrator, not even appearing in the arbitral.
No, I am the claimant, my lords. Where is the question? I am
No, but
seeking
for some
specific
reason-
relief. I am telling the arbitrator, you please hold your hands
But
until
that
I get
conduct
the
is
witnesses done.
absolutely inconsistent with what the submission has been made. But on the last occasion, we pointed out that conduct. The arbitrator sent emails to him saying, "I'm going ahead with the final hearing. Please appear before me." They refused. The arbitrator said there's no stay by the High Court. There is a Supreme Court deadline that has been given. Please appear before me. They said no. Look, this is not a case under 136. Your Lordship should be right.
When you want to just give me a moment.
Here of the claimant, because this property is, I think this.
Your Lordship will just give me a moment. I'm just.
And he overrides his lawyers. He writes emails directly.
Show me the email.
No, we'll tell him.
In fact, well, as a client, I believe the GPA directly communicates with the arbitrator.
May I make a suggestion?
Yes.
Well, if your Lordship is not inclined to look into this under 136, may I suggest that let it be 15th December. Let the time get extended to 15th December. Now I'll follow. I'll go back before the arbitrator and place before him.
They're not inclined to interfere with the impugned order of the division bench of the High Court of Telangana, dated 6 September 2024. To stop, however, on the request of Mr. Shyam Diwan, 11th Senior Counsel, time for completion of the arbitral proceedings shall stand extended until 15 December 2020.
I'm grateful.
I'm deeply grateful.
Item 50.
My lords, in item 50.
Article 32 petition.
But my lords.
Very ambitious
I
petition.
go down to that. I'll explain my lordships. My lordships can just look at the situation.
Formation of an SIT to investigate cyber attacks. Monitoring of investigation by the High Court or a retired Supreme Court Justice. To safeguard the funds on the WazirX platform. Minimum protection standards for user funds and custody and guidelines for regulating virtual digital assets.
Can I just explain my case? Then I leave it to my lordship.
Yes.
My lordships, petitioners today are small-time investors in the largest, biggest crypto exchange of the country called WazirX. On 8th July, my lordships, there was a cyber attack on this particular exchange. 2,000 crores were sucked out to Tornado Cash. It went abroad. Nobody knows where the money went. The total money.
To file a criminal complaint,
My
you can activate the criminal law.
My lords, I'll just.
But now not a case for 32. For all we know, this may be at the behest of WazirX.
No, my lordship. Can I go down to that, my lordship? Can I just explain my case, my lordship? My lordship, both. What happens is after this money moves out, at that particular moment, 4,700 crore worth of assets were with WazirX. Now, effectively, the respondent number 9, which is the Zanmai, which is an Indian entity, was supposed to control this. Can I just explain?
These are not matters for Supreme Court to monitor investigation.
If there is no regulation for a particular area.
Your case is that there was a cyber attack on WazirX.
Not just that, my lordship.
4,700 crores was taken out. We don't know who is responsible for it, but we refuse to get involved in this. The criminal process, the criminal law is available. You can pursue your employer.
I put in RTI, I go. Where do I go? I am remediless today.
You file a criminal complaint and get the criminal
But
law.
my lordships, nobody knows. Can a constable handle something like this? Who will handle it? Today, my lordship.
You don't want, certainly not a retired judge. A retired judge is not going to handle this kind of.
Can I just explain my case, my lordships?
You're not inclined to entertain a 32 petition. Thank you.
My lordships can just hear us out.
No, sorry. We've indicated why we are not.
Then
Item
let us
51.
withdraw the petition. We'll take appropriate remedy.
Sure, you can. With 51,
Allowed idea for the petition.
we've already passed an order.
That order is limited only to the petitioners, my lords. The
These-
college has actually passed an office order wherein it's limited only to the petitioners
So
earlier.
these are the remaining students.
Yes.
Those students deposited the undertaking in the High Court. The High Court then clarified that it will be applicable to all candidates on 24th of August. These petitioners approached the High Court on 26th And the High Court said, you give us the undertaking, we'll specially sit today.
What did our order direct that they have to file an
7.5
undertaking?
and undertaking.
Where is the order of the
My
High
lords,
Court of 26? Let's
Yes,
see
I
that.
have that.
Give us a copy.
Of the Supreme Court, my lords.
We want our order
Yes.
and the High Court's subsequent order.
So the High Court said, provide us the undertaking.
I think we had said they'll pay 7.5 lakhs
Yes,
of rupees.
My lords, we are seeking.
Because their documents were being withheld by the medical college, they were not able to do their PG.
Yes, my lords.
So we said that pay 7.5 lakhs and now release the document.
Undertaking.
Correct? That was what
Yes,
I
my lord, and undertaking.
they
Now
got
they are,
direct that conditional on the petitioners depositing an amount of 7.5 lakhs each. They shall be entitled to a return of their original documents submitted at the time. The subjects shall file an undertaking to pay the balance amount in the event that they are called upon to do so at the final disposal.
now they are not willing to give the undertaking.
My lords,
The
we
High
are-
Court said that you give us the undertaking,
What is the date of the order? 24th September.
24th, and this
Let's
is
see that.
para 7, my lord. So it became applicable to all students, including them. And they went to the High Court. And the High Court said, we'll specially sit today at 1 p.m. for you. You please provide us the undertaking. And then they informed the High Court that it's listed
That
here.
the candidates who have furnished the undertaking as per paragraph number 15 of the order dated so and so passed by the Supreme Court will be given all the documents, including the original degree of MBBS by the college. You just file your undertaking.
Yes.
Yes, my lords. My lords, may kindly have a look at the office order which is passed by the college. They say it's only limited to the petitioners.
This order is after that, my lord.
But this is 24th of September.
Yes.
My lords,
What is that document?
29, 2024, they've issued an office.
Before
order
that.
Which restricts it.
29 means 20th September.
Yes, my lord.
That is followed by 24th order of the High
My
Court.
lords, I wasn't, this
No, they
order
were,
was not.
they are before the High
Well,
Court.
before the High Court, we'll not explain.
My lords, may kindly clarify that it applies to all finally.
High Court has clarified that it applies to, take a copy of the order.
Obliged.
52 का क्या हुआ?
Lordships, I won't say much except draw your lordship's attention to page 153.
Which item is this now?
I'm sorry, 53, your lordship. It was mentioned and listed before your lordships. Lordships, I just want to draw your lordship's attention to page 1, 2, and 52. And some orders which have been passed in terrorum, your lordships.
Draw what? The Director of Geology and Mining.
Yes, your lordships. I am the initial complainant
Yes.
who had filed this FIR, your lordships,
Against R1.
against R1, the accused. Now, when he goes in for quashing, there is no material which has been taken by the investigating authority, which is considered. A vermin's made in 482 petition become the material before the Honorable High Court. This is how this matter has proceeded. Your lordships will kindly see page 2. Paragraph 7. And there are 2 or 3 other worrisome aspects which I will point out to your lordships. First, I'll point out what is the material and on what basis have these orders been issued. Para 7. It is submitted by learned counsel for petitioner that petitioner is innocent and has been falsely implicated.
Moment.
Please, your lordship. I'm sorry.
An allegation of bias against the judge, or what are you pressing that allegation?
Yes, your lordships. I'm clearly placing that because he was the counsel of the opposite party, of another party where I was a respondent. At page 51, the writ petition was filed by him. That's why I'm pointing out page 52, your lordships.
Just give us a moment. Which is the order which you are challenging? The first order is of the 29th of August.
Yes, yes, your lordship.
Lieutenant Advocate General submits before this court that the government will constitute an SIT.
Yes, your lordship.
And SIT will examine the entire issue and submit a report in a sealed envelope after 1 month.
Where instead of being a complainant, now I'm an accused. And lordships will see that this is predicated on the order which is dated 29th of April 24, which is page 2.
Right. Where have you been made an accused now?
Because I'm now being summoned by SIT every day. That's why I had.
Cooperate with the SIT. If you have an allegation of bias against the judge,
Yes, Your Lordship.
you can move the Chief Justice on the administrative side.
Absolutely, I will do that. Do
So
that.
why do you want to press this here?
21 issue which is coming up before your lordships, and my main grievance is how is Bhajan Lal to be applied, your lordships? A verment in a writ petition can never meet the sub 7 grounds.
All that the High Court has done in the 29th of August order
Yes.
is to record the statement
But
of
your
the
lordships will see 2-3 very
that the government will constitute an SIT.
Your
Why should we
Lordship,
interfere at this stage?
because that SIT is of grave, there has to be some semblance of there has to be some complaint. There has to be some FIR against me. There has to be some basis of an SIT to be constituted against me. This can't be darkness at noon that I'm called for answering allegations which are not even made against me. And lordships will see page 39.
What's going on? Why should we stop the
Investigation.
You are what? R3 before the High Court?
No, your lordships. I was not even a party there.
Yes. It
Lordship,
is submitted that the impugned, see the earlier order, para 10, it is submitted that the impugned first information report has been lodged on 15 April 24
yes.
as a counterblast to the complaint made to the SSP on 12th April by the petitioner, and the respondent number 3, by using his official powers, manipulated the date of the complaint in the impugned FIR, which was mentioned 11 April 24. That's the allegation.
Lordships, but I should be made a party before the High Court, before such orders are passed.
Ultimately, it's an SIT. You have to cooperate in the investigation. That's all.
SIT also has the powers to call me to their offices, to hold me, your lordships. Also, one more thing I want to point out to your lordships, page 39. Page 39, may I point out to your lordships? And just as an aside, your lordships, this time one of the main questions in our AOR exam was that when a judge should recuse himself, your lordships. So,
you know, if there's some allegation of bias, you can move the Chief Justice.
yes, all that I'm saying.
Chief Justice can always transfer a case. These are administrative orders of the Chief Justice.
Your lordships, let this be a matter where your lordships may ask the Honorable Chief Justice to place it before some other bench. Let fairness be done.
You either ask for recusal before that court, and if he declines, then you can come here. Otherwise, you can move the Chief Justice on the administrative side. Without making an application for recusal by that judge, you come here directly. It's unfair to that judge. Today, we just say, give it to some other judge. He'll say, what have I done?
Very well. I'll make that application, but your lordships may protect me for 4 weeks till I make that application.
We'll not.
Because your lordships.
No, Miss.
Because that application will never be heard. That is another problem that I have.
Why? The Chief Justice will look at the application.
I'm placing before your lordships may take my request that I withdraw this with permission to file appropriate proceedings in the High Court. And in the meantime,
that's all that we'll say.
Your lordships, this order may not be
We
implemented.
say that Ms. Vibhatakta Mukhija, London Senior Counsel, is permitted on her request to withdraw the petition with first to enable the petitioner to take recourse to such remedies as are available before the High Court.
Very well. And in the meanwhile, your lordships will protect me only for 2 weeks. I will move.
No protection on the SIT.
Your lordships, I will move immediately.
No, Miss.
And your lordships, unfortunately, this will prejudice me. Yes. Now there'll be a suspension, a whole lot of host
Move
of
the High Court. Yes, you have your whole remedies. Yes.
Very well.
Item 54.
Lordships may say nothing has been said on merits.
We have not said anything on that.
Lordships may say that.
No, but we have clarified that you are not, that you want to withdraw it. Where we saying?
Not saying also says.
No, but we don't say, we have not made any finding on merits. So if we just show the order that we merely withdrew this.
Very great.
54.
Please, your lordships. In 54, your lordships, a reply has now come from the
NBE, Milos.
NBE.
You're appealing for the National Board of Examinations?
Yes, your lordships.
Please, Milos. But Milos, R2 is not here, and I think service report says that they have not been.
Who's R2?
Union.
Yes, your lordships, we've served.
Milos, actually, they are the ones who conduct the counselling. So their interim prayer is against Union of
They have been served through the Standing Council, your lordships.
Why don't you normally, Union of India is here. I mean, they always appear in medical matters.
And we've served the Standing Council also, your lordships.
On the other day also, Milos, when the matter had come up, no one was there. And then, Milos, my AOR, he requested also, Milos, he called up some counsel on this.
We'll keep it on Monday.
Very well.
Let the Union of India come here because they are in charge of counselling.
Please, your lordships. There's one.
None appears on behalf of the Union of India.
Okay.
We request the presence of any of the additional solicitors general
Yes.
to assist this court. Full stop. A copy of the order may be communicated to the office of the Solicitor General so that necessary arrangements can be made for representation of the Union of India.
Your Lordships, there's only one thing I wanted to bring to your Lordship's notice, that we have filed these additional documents. Usually what happens for counselling, your Lordships, a schedule is fixed. This year, your Lordships, on 20th, when your Lordships issued notice in the morning, in the evening, a one-page notice, your Lordships, has been issued that it will begin at 5 p.m. So registrations have been called for, no schedule, no pro forma, no information
Let the
bulletin.
union come on
Yes,
the next day so that we'll see what they are doing.
Yes, your Lordships. Great.
Today, because I don't.
Lordships may have the order out today.
Yes, it will be out.
Great.
55 which will have to be tagged with Rakesh Reddy's matter, isn't it?
Yes, ma'am.
That is SLP 11.